Court is on the record in City of Pontiac versus Todd Estes II, case number 25 CRB 131. In this case, Mr. Estes pled not guilty to one count of domestic violence, a first-degree misdemeanor, on May 12, 2025. We conducted a first pretrial conference on May 21st, and today we're scheduled for a second pretrial conference in that case. In these cases, Mr. Estes pled not guilty to one count of burglary, a second-degree felony in the CRA case, and one count of domestic violence, a fourth-degree misdemeanor in the CRB case. These cases are set for a preliminary hearing and pretrial conference today. I understand that we're running a preliminary hearing, Mr. Lewis?
It will appear that way, Your Honor.
Okay. Go ahead and call your first. Any argument, counsel?
No, Your Honor.
Wait, that is not.
Okay, call your first witness, Mr. Lewis.
Your Honor, the state of Ohio will call Dakota Mullen.
Before you're seated, ma'am, can you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Yes. Okay.
Buckle up, guys. Today we're going to witness a tense courtroom showdown. The judge opens a record, laying out charges against Todd Estes for burglary and domestic violence, and notes prior proceedings. The air is heavy with anticipation as the stage is set for testimony that could drastically impact Estes' fate. Every word counts in this high-stakes pre-trial conference.
Okay, you may be seated. Ms. Mullen, can you ensure that you speak loudly and clearly so that we can make a proper record of this proceeding, okay?
Are you familiar with the defendant, Todd Estes?
Yes.
And how are you familiar with him?
He's my boyfriend.
Are you involved in a domestic violence case with Mr. Estes?
Yes.
You're the victim and he is the defendant.
Yes.
Yes?
Yes. I'm sorry.
And is there a no contact order to your knowledge in that case?
Yes.
Yes?
Yes.
Okay. I want to direct your attention to May 16th of 2025. Did you encounter Mr. Estes that day?
Yes. Yes.
Yes? How did you encounter him that day?
He was at my window.
I can't hear you.
I'm sorry. He was at my window. That was the day that the burglar, I can't say the word, when he came to my window.
He came to your window?
Oh, I don't know what date that was. I don't remember what happened on the date. Is this for the, burglary charge? I'm sorry, I can't say the word. Yes, he came to my window, yeah.
Came to your window?
Yes.
Which window?
Back window.
Of your house?
Yes.
What happened next?
We talked through the window, and he came in. But it was no aggression, nothing like that. I gave him water, and then was walking him out, and that's when I sprayed him.
Dakota Mullen takes a stand, visibly nervous, as she recounts her connection to Estes and the events of May 16th. She describes the encounter at her window, hinting at conflict and a looming confrontation. As she speaks, the courtroom leans in, catching the first flickers of tension that will define the dispute between Estes and the law.
Your Honor, I can't hear what you say.
I'm sorry. I can't.
Speak up louder, man.
I lost my voice. He came to my window, and I gave him water after I had him give me all the stuff that he had of mine. And when I was escorting him out, that's when I sprayed him.
What, you sprayed him?
I maced him, yes.
Okay. Well, why did you mace him?
I used to be a CO. I always have mace on me. I used to be a CO. I always have mace on me, especially when they're with what happened. Just in case anything were to happen, I could protect myself.
Oh, just so I understand what you're saying. You're saying you allowed him to come into your house?
Yes.
You allowed him to?
The window was unlocked, yes. But I...
Did you tell Conneaut Police Department on May 16th that he climbed up the side of your house, came in the second story window?
Yes.
Okay, so which is true?
He climbed up to the second story and he came in my window, but I was there with water. After I talked to him and made sure he was there.
Did you tell the Conneaut Police Department that he lunged at you?
Yes, he did.
Okay, is that what you told the Conneaut Police Department that day?
Yes, and that is what happened.
And then you maced him? Is that what you...
Yes, that's when I was escorting him out. I don't know if it was aggressive or not, but regardless, I maced him because
Let me ask you this, what happened
fight or
after
flight.
you maced him?
He left, and I called the police.
Did he have permission to be in your home?
Legally, no. And technically, no.
Did he have permission to be in your home, yes or no?
No.
And you are aware that there is a no contact provision of his bond in the domestic violence case, is that correct?
Yes.
So just so we're clear here, your testimony is that on May 16th of this year, Mr. Estes climbed up the side of your house, is that
Yes.
correct?
Yes.
And he came in through a second story window,
Yes.
okay? Was he permitted to come into your house that day?
Legally, no.
Okay. And he lunged at you?
As I was escorting him out, yes.
So yes.
Yes.
And then you maced him.
Yes.
And then what happened after that?
He left. He ran, and I called the police.
The intensity ramps up as Dakota reveals she maced Estes while escorting him out. Her testimony mixes hesitation and conviction, exposing contradictions about whether Estes entered by force or consent. Each detail about the mace, his behavior, and her protective instinct ratchets up suspense, leaving the courtroom questioning who was truly in the wrong.
And you called the police?
Yes.
And did the police come?
Yes.
Do you remember who you spoke to that evening?
Police
Officer?
Officer Dan and it was you, right? Him and him.
And did you give a written statement to the police officers?
I just agreed with the questions. I didn't write anything,
Okay.
but
They took a statement from you?
yes.
And you described to them what you just basically described
Yes.
to us, correct? You indicated that Mr. Estes lunged at you, is that correct?
Yes.
And then you maced him.
Yes.
And then after you maced him, he fled, is that correct?
Yes.
I have no further questions at this time, Your Honor. Thank you.
Thank you, Mr. Sayed.
Thank you, Your Honor. Good afternoon, Dakota.
Sorry. Good afternoon. Sorry, it's hard seeing him like that.
First, how did you get here today?
I was escorted here.
By who?
An officer, they suspended my license.
So the police department came and got you here?
Yes,
How long have you known Todd?
a long time.
Roughly how many years?
I met him when I was 17.
How old are you now?
I'm 24.
So 7 years.
Yeah, oh my god, yeah.
How long have you guys been dating?
Since right after Christmas.
This past Christmas.
Yes.
So 5 months? 6 months now? Almost? You guys are still dating?
Yeah.
Hold on. You don't speak. Go ahead. Answer his question. Are you still dating?
Yes.
You two are still together.
As far as I'm aware, yes.
Was your relationship always rocky from the start?
No.
It was good in the beginning?
Yes, sir.
So let's talk about, first, the prosecutor brought up the fact that there's an ongoing domestic violence case with Todd. Is that correct?
Yes.
Who else has an ongoing domestic violence case against you?
Objection.
Yeah, sustained.
Let's talk about the incident that happened on May 16th, 2025.
Yes.
Okay? You said Todd climbed up the second story.
Yes.
How did he climb up the second story?
A ladder.
Okay. He brought a ladder with him?
No, my backyard is filled with junk. It's not that hard to get in any window in the house.
Did you know he was coming?
No.
Did you leave the door, did you leave the window open?
No, I opened it.
You opened it for him?
Yes.
You let him in?
After seeing his feet bleeding, him needing water, and he hasn't eaten in days, or I haven't heard from him in days, yeah.
So you let him in?
I unlocked the window after getting my belongings, which included stuff from my car, yes. To give him water and food and clothes that he wanted, that's what he came there for. And I went to go escort him out, and that's...
Okay. So, I'm sorry, I didn't hear, I know you lost your voice.
I'm sorry.
You said he came with your belongings and then he left with his belongings?
He didn't get the chance to get his belongings because I felt safer if he was out back.
Okay.
Well, I grabbed his bag that I already had packed. But we were, I honestly don't remember if we were arguing or what, but I wanted him to outside, and I kind of blacked out after that.
But you allowed Mr. Estes to come inside?
Yes. Legally, he was not allowed there, but yes, I did let him in.
So that's what you meant earlier when you said legally, no?
Yes.
But you let him inside?
Yes.
There was no forced entry?
No.
Mr. Estes didn't break the glass to get in? He didn't use a weapon?
He didn't even try to break in a door. He knocked on the window.
Okay.
He was not aggressive at all. He needed help.
He wasn't stealthy?
To
But he wasn't trying to sneak in and catch you
No.
by surprise? Okay. He didn't use a deceitful manner to come inside your house? Like pretending to be someone outside?
No, he said, please let me get my things. I want to go. Let me get some water. I'm hot. I'm his only home out here. And after I retrieved the things he took from my car, and I felt safe enough to grab his bag, give him water, food, and shoes, and send him on his way, I opened the window.
The shoes you gave him, were they his?
He did not end up getting shoes.
Okay.
When he came in, I said, can we go downstairs so I feel safe when you're outside? I'll grab everything I already have packed and whatnot. And he didn't end up leaving with any of his belongings. But the shoes would have been his, yeah.
The shoes would have, okay, so can we back up a little bit, please?
Yes.
So, Mr. Estes was living with you.
Yes.
Cross-examination digs deeper into permission and entry, revealing a messy tangle of legal versus personal consent. Dakota admits she let Estes in despite his legal restrictions, describing his second-story window entrance. Every back and forth between counsel and witness heightens tension, as observers watch the story unfold with unclear lines between crime and care.
Yes.
How long were you guys living together?
He was since January, early January, first week.
So the beginning of your relationship, you guys were already living together?
Practically, yeah.
Okay. So his stuff was there.
Everything of his is there.
Everything of his was there.
Yes.
So that night on May 16th, and when you let him in, he was just grabbing his stuff. He wanted to grab his stuff.
Yes.
Okay. So he wasn't trying to take anyone else's property. Who else lives with you in this home? What do you thought?
Me, my mother,
Mhm.
and my stepdad.
So total 5 people.
4.
Oh, okay, I'm sorry, 4 people.
Yeah.
So 4 people. So when Todd came that night, okay, he didn't give you the impression he was trying to take.
It was still daytime.
Oh, the daytime. Okay, he didn't give you the impression he was trying to take anyone else's belongings.
No, he was not aggressive. He was just begging for his things and water. And I how roughed up his feet were. He looked a mess and he needed help. And I'm the only person he knows out here that would be willing to help him. And I don't care who it is. If they look like they're dying, I'm going to help them.
Do you still love Todd?
Yes.
You love him right now?
Yeah.
You care for him?
Yes.
That's why you let him in that night.
Yes.
Your Honor, I have no further questions.
Thank you. Any redirect?
Yes, Your Honor, thank you. Ms. Mullen, why didn't you just let Mr. Estes in the front door?
I didn't hear him knocking.
He knocked on the front door?
That's what he said. I've been knocking for a minute out. I don't know how long, but I did not hear it.
Why would someone who was welcome in your home put a ladder up against your house and climb up the side of the house and enter through a second-story window?
Because the doors were locked and I was not answering because I had music playing, so I did not hear him knocking.
So your testimony today is that you let him into the house. Is that correct?
Yes.
When you just testified, when I was questioning you, that he did not have permission to be in your house.
Legally, no. He did not have permission to be in the house. If it was a different circumstance,
So if everything was so nice and lovey-dovey on May 16th, 2025, why did you mace him, and why didn't you call the cops?
I maced him because I was trained as a CO that if anybody lunges at me, I protect myself. And he needs psychiatric help. I don't know who or what state of mind he was in when he lunged at me, but regardless of who it is, if I feel that I could be in danger, I'm going to protect myself. But he seemed fine upstairs. I don't know why he lunged. I don't know.
So if he had permission to be in your house in this moment, why'd you call the cops?
I called the cops because he lunged at me. But
He lunged at you.
yes,
Okay. You didn't tell the cops that he came up the side of your house on a ladder, came in through a window. You didn't tell the officers any of that?
no, I did.
Okay.
That's exactly what happened too.
Testifying, Mr. Syed said you let him in the house.
Yes, I said he came into the window. He did not break in the window.
Oh, okay. So you let him in the house?
Through the window
Story window.
that he climbed up, yes. But if it was different circumstances, if he was aggressive at the window, if he had intentions of malicious intent, I would not have let him in.
You didn't hear him knocking on the front door, but you heard
It
him
was-
knocking on a second-story window. Is that your testimony?
Because it's right by my room. It's right by my room, and he was knocking at the back door, I guess, because my stepdad screws the front door shut, so you can't get in there.
Connor, I'm going to approach the witness, if I may, and offer her, this is going to be State's Exhibit A. This is a written statement that she provided to law enforcement that night because her testimony is way off base from what this written statement says.
Objection, Your Honor.
Good.
She stated that the police officers wrote the statement for her. She never actually wrote a statement.
And,
Did she testify that?
I believe she did earlier.
yeah,
That's why I brought it up.
So there's a statement that you have that she signed. Does it have her signature?
There appears to be two different handwritings on here, Your Honor. I would assume one of those handwritings belongs to Ms. Mullen.
Okay. So are you trying to treat this witness as hostile?
I'm sorry, Your
Are
Honor.
you trying to treat this witness, your witness, as hostile right now?
Yes, Your Honor. She's given testimony here today that is not at all consistent with what.
Let me
she
see your
said to law
statement.
enforcement.
Glenn. Let me see your statement. Here, we'll get it. Go ahead. I'm allowing the prosecution to treat Ms. Mullen as a hostile witness.
What do you have there in your hands, Ms. Mullen?
the statement that was written on the 16th.
Okay, is your handwriting appear on that document?
Yeah.
What part of that is your handwriting?
The top part.
The first paragraph?
Yes.
Could you read that for the court?
Todd Estes climbed up the side of my house. He came in my window. As I was walking him out, he lunged at me and I maced him and he ran out the back door.
Anything in there about you let him in the house?
No, I just said he came in the window.
Could you read the rest of the written statement?
Yes. I'm sorry, I'm having a hard time reading it. Did Mr. Estes have permission to be in the house? No. Which I meant legally. Is Mr. Estes allowed to have contact with you? No contact order? No. Do you want to pursue charges against him? No. Did Mr. Estes... I'm sorry,
Go ahead.
I can't read it.
That's fine, that's fine. So anything in that written statement about that you let Mr. Estes into your house? No. Anything in there about giving him his belongings?
No.
And in that statement, you indicated that he did not have permission to be in your home, is that correct?
Yes, because legally he could not.
Sorry?
Yes, because he legally could not be there.
And you maced him,
Yes.
and you called the cops.
Yes. I've seen a switch in his eyes and he needs help. He needs medication. So I don't know what he changed to, but whether it was malicious or not, I'm not taking chances. I maced him, yes.
So just to be clear, you did not tell Officer Burlingham or any other officer that you let him in your house. Is that true?
I can't recall.
Redirect and confrontation cast Dakota as a hostile witness, challenging consistency of her account against her written statement. Prosecution and defense spar over the truth, highlighting gaps and contradictions. Observers can feel the courtroom drama peak as the narrative teeters between personal bias, legal strategy, and the stark reality of the May 16th incident.
Can't recall, but on here is no.
So you didn't tell them that?
No.
Okay. What did you tell them?
I told him that he came in my window.
And that you didn't have permission to be there, correct?
Legally, no.
Thank you. No further questions. Sorry, John.
Thank you. Yeah, I'll just allow some recross on what Mr. Lewis just asked. Any recross?
Thank you, Your Honor. Dakota, I understand on the witness statement, it says you never mentioned anything about not letting him in. Your window was open, correct? Or you opened it?
I opened it.
You opened it. For Todd.
Yes.
Okay. No further questions, Your Honor.
Thank you. You're excused, Ms. Mullen, but you're not going anywhere because we have a traffic case we have to address with you after this is over. So you can go to the back of the courtroom.
I'll leave it here. I'm sorry.
Argument, Mr. Lewis.
Thank you, Your Honor. Clearly, Ms. Mullen is a little bit confused, maybe not sure what she wanted to do with this case. She indicated in the written statement there, states today, that she didn't want to press charges. That's fine, but if you don't want to press charges, why do you call the police to your home? Why do you mace the individual that you told officers did not have permission to come into your house and enter through a second-story window? Why would you do these things? She clearly, in her mind, testified that her and Mr. Estes are still in a relationship. She has a bias of trying to protect Mr. Estes from this prosecution. But it's clear, Your Honor, based on her testimony, her written statement, Officer Burlingham's testimony about smelling mace in the house, that the version of events that she gave to officers in that written statement, State's Exhibit A, is what is true. Why else would she have called law enforcement on that night if it were not true? There's evidence of a ladder Officer Burlingham saw the ladder that shows that Mr. Estes entered the home through a second-story window, knocked on a window that was apparently non-existent, and came into the home. Your Honor, the complaint indicates that on or about May 16th, City of Conneaut, Mr. Estes did by force, stealth, or deception rather, trespass in an occupied structure. Another person other than an accomplice was present, namely Dakota Mullins, with the purpose to commit in the structure any criminal offense, to wit, domestic violence. Contrary to Mr. Syed's argument, he is charged with lunging at her. That is where the domestic violence count comes in under 2919.25C. Your Honor, the victim, alleged victim's own statement makes it clear that the state of Ohio has shown probable cause that Mr. Estes committed a burglary on May 16th. And the state of Ohio is requesting that the case be bound over to the grand jury for their consideration, and the misdemeanor of the case would also accompany that. It's clear that Ms. Estes was telling partial truths when she was here on the stand, and that her written statement is in fact a clearer recitation of what actually happened on May 16th. Thank you, Your Honor.
Thank you, Mr. Sage.
Your Honor, this case is about whether Todd Estes and we understand that Todd and Dakota have a complicated history. I know this, the law director knows this, this court knows this, okay? We're not here to talk about macing or lunch. We're here to see if he committed burglary, and if there's probable cause presented by that. There isn't any today. Mr. Lewis wants to paint this picture that Dakota's been lying. She didn't lie. The witness statement is true to what she's been testifying today. The window was open, he came in through the window. She didn't go into detail. Obviously, it's a sheet of paper, which to the court's attention I have not seen. But she stated she let him in, she let him have water. She stated there was no force, there was no stealth, there was no deception. We've heard from Officer Birmingham. He investigated the scene. He said there was no force detected. We know that there was a ladder there because Dakota said that there was that her stepdad keeps strong in the back and there was ladders back there. In her own words, I allowed him to come in. That's not trespass. And if there's no trespass, there's no burglary. So at this time, Your Honor, there's not enough probable cause here for this to get bound over. He doesn't meet the requirements of burglary. There was no force, there was no stealth, and there was no deception. Dakota welcomed him in as if he was a guest. She took care of him. She even mentioned, I wanted him to grab his belongings because his belongings weren't there. They lived together since January. He was returning her belongings, I believe. So for the evidence presented today, including her testimony and the testimony of Officer Birmingham that there was no force, this does not meet the statutory requirements of...
The attorneys clash over whether Estes committed burglary, dissecting evidence like ladders, mace, and witness accounts. Each argument is meticulous, the tension palpable as the prosecution frames stealth and force, while the defense highlights consent and hospitality. This high-stakes debate grips the courtroom, leaving everyone on edge over the outcome.
Of Revised Code 2911.12. Thank you, Your Honor.
Thank you. Any argument responding, Mr. Lewis?
Well, contrary to what Mr. Syed is saying, there doesn't need to be force. There can be stealth. I don't think it's... I think that the circumstantial evidence, aside from Ms. Mullen's testimony, shows what happened here, Your Honor. She called law enforcement. She called 911. That's why they responded. She also maced Mr. Estes, and the officer Burlingham testified they could still smell the mace in the house. So you've got a ladder leaning up against a window. You've got an individual who was maced, and you've got a young lady who called the police and initially told the police that he entered through a second-story window and that he had no permission to be in the house. And that's what her written statement says. You don't have to show forced entry here, Your Honor. It could be by force, stealth, or deception. Thank you, Your Honor.
Thank you. So one thing I wanted to address is 25 CRB 131. This is the original domestic violence case. He was charged, he pled not guilty, domestic. I ordered as conditions of his bond that he have no contact with Dakota Mullen and remain off the premise. He entered that plea on May 12th. We conducted a pretrial conference on May 21st, at which time the law director orally withdrew its motion to revoke bond that was filed on May 19th. So I just want to make sure that that was orally withdrawn.
It was, Your Honor. At the hearing, Ms. Mullen did not appear for that hearing. The court would recall, and then I had no choice but to withdraw my motion at that time.
Okay. Okay, in looking at Ms. Mullen's written statement, Todd Esty climbed up the side of my house, came in the window, and then something walking out, he lunged at me. I maced him, he ran off the back door. In her written statement, and even in the questions that follow, it doesn't mention about how he entered the second story of the home, whether she let him in or not. I'm sure in calling the police, she probably led the police. That's why they did the investigation, to believe that he probably was there. But at least with respect to consistency of testimony here between her written statement and her testimony today, there doesn't seem to be inconsistency about how he entered, whether she let him in or whether she knew about it. But her testimony today is that she allowed him to enter to get his clothes. So, yeah, I did order him to stay out in the 25 CR 31 case, but that cannot be used as a basis for trespass. I'll deal with that here shortly. So not only did Mr. Estes not trespass, but there's no evidence that he entered this property with purpose to commit domestic violence. There's no evidence whatsoever. That was his reason, based on Ms. Mullen, was to get clothes and to get water, and something happened as she was walking him out. I do find, based on the evidence presented after preliminary hearing today, that probable cause has not been established for the offense of burglary in case number 25 CRA 148, and this case, bond will be discharged, and this case will be dismissed. We will schedule 25 CRB 149, that's the domestic violence case, for another pretrial conference on the same date as the other cases for June 2nd, 2025 at 9 a.m. I am revoking the defendant's bond based on the testimony, whether there's a pending motion or not. In 25 CRB 131, the court's own motion, the defendant clearly violated the court's bond in 25 CRB 131 when I ordered him to have no contact with Dakota Mullen and to remain off the premise. I did allow him to retrieve his personal belongings at that residence with a police escort only. And that didn't happen. And I guess people don't care what I ordered and guess conditions of his bond, so I'm revoking his bond in that case. And he will
The judge delivers a decisive ruling. No probable cause for burglary, but bond is revoked for domestic violence violations. The courtroom holds a collective breath as Estes' fate shifts dramatically. This turning point crystallizes the consequences of testimony, actions, and prior orders, blending legal judgment with suspense that only real-life drama can deliver.
And he will be held without bond in that case. In this case, will as well be set for another pretrial conference for June 2nd at 9 a.m. Okay. I think I've addressed everything. Is there anything further, Mr. Lewis?
No, Your Honor.
Mr. Syed?
No, Your Honor, not this time. Thank you.
Okay. Mr. Mullen or Mr. Estes will be taken back down to jail, where he'll be held until June 2nd. Ms. Mullen, step forward, please.
Well, we will see you Monday. Love you too.
See you Saturday.
Yeah, we'll see you Saturday. Oh, yes, we'll see you Saturday. Thank you, sir.
Officer, if you need to go somewhere else, you can. You can stick around. It's up to you.
I gave her right here. I'll probably give her.
Oh, that's right. Okay.
She's got another one.
Sorry about that. I didn't know that.
Do you need somebody to take it? Oh, okay, you don't. Okay.
Courtroom procedures wrap up as Estes is taken back into custody, and Dakota is sent to the back. Observers witness the immediate aftermath of the ruling, a quiet tension settling over the courtroom. While procedural, these moments underscore the gravity of the situation and the strict enforcement of judicial decisions.
Okay, you don't. Okay.
Okay, the court is on the record in the City of Conneaut versus Dakota Mullen, 25 TRD 380. Ms. Mullen failed to appear for an initial appearance hearing on a traffic citation that was issued on May 11th, 2025. She failed to appear, and as a result of her failure to appear, the court went ahead and started the process of issuing a license forfeiture. Ms. Mullen just testified in another case, and she is present. Ms. Mullen, a traffic citation was issued against you on May 11th, 2025. It appears to have your signature on the side of it. Did you receive a copy of that traffic ticket?
Oh, yes, sir. I did.
Okay, why were you not here at the last hearing?
Actually just talking to the officer about it. I thought it was for next month on the 11th.
Okay, well,
I guess it was written on the 11th, so I just did not read the ticket correctly.
no, you didn't. Okay, I'm going to read you your rights, so please pay attention to the rights I'm about to read to you. You'd have a right to be informed of and understand the nature and the elements of the charge filed against you. You also have a right to know the potential penalties that could be imposed. You're charged with one count of failure to illuminate a rear license plate. This is a minor misdemeanor, is punishable by a maximum $150 fine and court costs. You understand that?
Yes.
You have a right to remain silent and not to say anything during this hearing that might incriminate yourself. Any statement you make could be used against you. You also have a right to a trial to the court. At trial, you have a right to cross-examine witnesses and to confront evidence presented against you. You have a right to use the court process to secure the attendance of any witness who you would want to testify on your behalf. At trial, you have a right to be proven guilty beyond a reasonable doubt and a right not to testify. You also have a right to have an attorney represent you in this proceeding. You are not entitled to court-appointed counsel. This is not a jailable offense, but you can retain the services of your own attorney at your own expense for representation and counsel. Ms. Mullen, do you have any questions regarding the rights or plea options I've just explained?
Yes, sir. I'm right. I just truthfully. I'm not going to be getting anybody to represent me.
You're what?
I'm not going to be getting anybody to represent me or anything.
You're not entitled to court-appointed counsel. Do you have any questions regarding the rights or plea options I've just explained to you?
No. I'm not
Okay, so how would you wish to plead to this charge?
guilty.
You'd be waiving your right to be proven guilty in a courtroom of this offense.
Yeah. I'm just going to plead.
I understand you're going to plead guilty, but I need to understand that you understand what rights you're waiving by pleading guilty. Okay, by pleading guilty to this charge, do you understand that you are waiving your right to a trial?
Yes, Your Honor.
You'd also be waiving your right to an attorney at your own expense. Do you understand that?
Yes.
Court does find the defendant's plea of guilty to this charge, minor misdemeanor offense, to be knowing, voluntary, and intelligent, for it will accept the guilty plea, and I will therefore find her guilty of this charge. Ms. Mullen, do you have anything you would like to say before I impose the sentence?
My license was suspended. I just need to know how much to get reinstated and court fine cost.
we started the process of suspending your license because you failed to appear. But you can resolve that with the court. I don't know if you got a license suspension from anyone else, but okay. Is there anything else you'd like to say before I impose sentence?
If you have no answers for fees or anything, then no.
Okay, I'm imposing $150 fine plus court costs. Total fines and costs will be $302. How much time do you need to pay it in full?
Maybe like 2 months.
I'll give you until July 31st, 2025. We will set this case for a review hearing after July 31st. If you fail to appear for that review hearing and have failed to pay it in full by the deadline, I will issue a warrant for your arrest. If you have paid it in full by the deadline, we'll cancel the review hearing. Okay, do you have any questions for me?
So the starting process of my license being suspended.
You can talk to the clerk about getting that resolved.
No further questions.
Okay, thank you very much. You can go to the first window, they'll take care of you.
Dakota faces a minor traffic hearing, pleading guilty for failing to appear and resolving fines. The tension is lighter but still real as her license and court obligations are addressed. The session concludes with a clear resolution, bringing finality to the courtroom drama.